Peace and Justice of Eastern Maine. And we have today speaking to us Frank Panopoulos. He's a human rights attorney who's worked for nonviolence, peace, and social justice since 1979. Frank spent time in prison for acts of nonviolent civil disobedience, including 2 plowshares actions in the 1980s. His current work includes anti-drone war litigation and representation of prisoners held in Florida state prisons, and of course at the Guantanamo Bay prison, which is what he's presenting about today. So with that brief introduction, I will turn it over to Frank and whatever he wants to tell us.
Okay, well, thank you, Judd. And since this is a nice small group, I think I can take my time. So I'm not going to try and rush through this, although I'll try, and I think I can keep it to an hour and then take questions afterwards. So let me get to the. Can you all see that?
Yeah.
Yes.
Frank, do you mind the occasional question during during that first hour?
Yeah, I think that's fine, because then we don't have to go, the question and answer period would be shorter. So that's fine with me. If it's fine with everybody else, sure. Okay. So I'm going to present the Guantanamo Bay prison tonight. And let's see, right. So before I start, I just want us to take a moment to remember Oscar Romero, the Archbishop of San Salvador in El Salvador, who was assassinated 44 years tomorrow, and in 1980, in March of 1980. And about a month before his assassination, he had written a letter to then President Jimmy Carter, requesting that the U.S. stop sending military aid to the Salvadoran government because it was being used to supply death squads that were killing the Salvadoran population, as well as to repress the population. And, for his speaking out, he was assassinated. So he was a victim of a U.S. military policy, just like the prisoners at Guantanamo are. So if we can just take a second to, I'll dedicate this talk to Archbishop Oscar Romero, who was canonized as a saint by the Catholic Church. So the way I'm going to present tonight is, first, I'm going to talk about what's currently happening with the Guantanamo and the prisoners. The remaining prisoners and the current conditions, the periodic review board and the release of prisoners, post-release conditions. And then after that, I'm going to talk I'm going to talk historically and chronologically about how Guantanamo was established, the people behind the global war on terror, the false narratives about Guantanamo, about the architects of the global war on terror and how they dissembled the law to allow torture at Guantanamo. And then I'll end with, pointing out that Guantanamo isn't just there in Cuba, it's also in our own neighborhoods and in places around the world. And so I think Mike has a good suggestion. If you have any questions as I speak, don't save them for the end. Just interrupt me and ask me the question there. Okay? So I think this is a good enough group that we can do that. So who was sent to Guantanamo? So 779 men and boys, all of them Muslim, were imprisoned over time at Guantanamo since January 2002. 86% were sold to the U.S. for a bounty, typically $5,000. 22 or more were juveniles under 18 years old when taken in detention, and 9 died while detained in Guantanamo. And the U.S. refused to disclose the prisoners' names and the basis for their detention until April 2006, more than 4 years after people began arriving at Guantanamo. And it took litigation by the ACLU and the Center for Constitutional Rights and other attorneys to finally, get the court orders, including a Supreme Court, decisions allowing the prisoners representation by counsel to finally get the names. By the way, I document all of my sources for this information in the notes to the slides, and the slides and the notes will be made available to you so that you can follow up if you're interested in any of this with the sources I cite. Pakistan admitted it turned over prisoners to the U.S. for millions of dollars in bounties. In his book, In the Line of Fire, right, the former president, General Pervez Musharraf, right, boasts that Pakistan turned over 369 Al-Qaeda fighters to the U.S., and we earned bounties totaling millions of dollars, right? Who remains at Guantanamo, right? 30 men currently remain imprisoned. 19 have not been charged with any crime or offense and are indefinitely detained. 16 of these 19 were approved for release more than 2 years ago, but they're still there. 10 have active cases before military commissions. In other words, they're accused of war crimes for planning the 9/11 attacks, the Cole bombing, and the Bali bombings. One has already been convicted for conspiracy to commit a war crime and is serving a life sentence. And it costs more than $13.5 million per prisoner to operate Guantanamo. The UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, Finuela Neolane, issued a report in June of 2023 about the present conditions at Guantanamo. And in her report, she states that there still remains, near constant surveillance, forced cell extractions, undue use of restraints, and other arbitrary and problematic implementation of the special operating procedures at Guantanamo, that there are physical and mental health care deficiencies there for the prisoners. There's inadequate access to family, including facilitating meaningful familial calls and visits. The prisoners there can't have visits, physical visits from their family. So the International Committee on the Red Cross sets up monthly calls between the prisoner and his family. But according to the rules by the prison, you can only speak with one family member, with one set of family members at a time. So, for example, the prisoner that I represent, 1 month he can speak to his one sister, another month he can speak to his other sister, and then in another month he can speak to his wife and his children. So this is ridiculous, and the special rapporteur pointed it out in her report. There's also ongoing arbitrary detention at Guantanamo, characterized by a lack of fair trial and due process. And the totality of these factors, she concludes, amounts to ongoing cruel, inhuman, and degrading treatment at Guantanamo that may also meet the legal threshold for torture.
Frank, I have a quick question.
Sure. Go ahead, Mary Ellen.
How about your visits to your client?
Right. So my visits with his name is Abdul Malik are physical. I see him. I'm taken into the prison, and there's a facility that used to be basically some of the old solitary confinement cells that are now used for legal visits. And so I visit him, and I'm allowed to visit him for 3 hours at a time, once a day, Monday through Friday. While we visit, he's still shackled to the floor, and the visit is monitored and surveyed by the prison guards, by the MPs. But we're still able to speak, and we speak freely. Yep. Thank you, Mary Ellen. So I'll move on unless someone else has a question. Good. So the Supreme Court has yet to decide, after 22 years, whether non-citizen prisoners are entitled to constitutional due process, right? So Mr. Al-Hila, right, is from Yemen, and he's been held at Guantanamo since 2004 indefinitely and without any charge. He was cleared for release in June 2021, and he's still there. So he brought his case before the courts, arguing that his confinement there, his imprisonment there, is arbitrary because he's already been cleared for release, and in order to be cleared for release, the military declares that you're no longer a security threat to the U.S. So the case went before the District of Columbia Court of Appeals, the Federal Court of Appeals in the District of Columbia, and the court kicked the case back down to the district court for the district court to first decide whether or not Mr. El-Hila has a constitutional due process claim, right? So as yet, the litigation in the courts is ongoing about whether these prisoners even are entitled to constitutional due process. I myself have motions before the district court for Abdul Malik, arguing that his due process rights, that he has due process rights under our Constitution, and that they're being violated by his continued imprisonment there after he's been cleared for release. So the way to get released from Guantanamo is through the Periodic Review Board for those 19 prisoners there of the 30, the 19 who are held without charge, right? The Periodic Review Board was established by an executive order under President Obama in 2011. It's analogous to a parole board. It consists of representatives from the Department of Homeland Security, the Department of Defense, and the intelligence agencies, and the Justice Department, and the Defense Intelligence Agency. They hold a hearing every 3 years to review whether the prisoner should continue being detained, and continued law. And so they will decide to continue detaining the prisoner if it is necessary to protect against a significant threat to the security of the United States. In other words, if they decide and determine, based on evidence that's presented to them at the hearing, that the prisoner no longer is a significant threat to the security of the United States, they'll order his release, or they'll recommend his release. And so for Abdul Malik, for example, his hearing was in December of 2020, was in September of 2021. So we presented evidence to the Periodic Review Board that he was never a security threat, and definitely he's not now any significant threat to the security of the U.S. And we presented evidence that if he's released and transferred to his home country, he'll have a job, he'll have support by human rights, non-governmental organizations. And so in December, the Periodic Review Board decided that he was cleared for release. But the Periodic Review Board's determination doesn't mean that the prisoner can be released right away. Excuse me. The Secretary of Defense is not bound by the PRB's determination because it's only a recommendation to the Secretary of Defense. Typically, the Periodic Review Board recommends security arrangements be negotiated with between the U.S. and the country that will take the prisoner prior to releasing and transferring the prisoner to that country. And the Secretary of Defense must certify to Congress that the arrangement and transfer meets Congress's conditions before Congress approves funding the transfer. So what you have here is the PRB first has to recommend that you can be released. The Secretary of Defense has to agree to it, and then he has to certify to Congress that all of these conditions that Congress puts for the transfer are met. And then if Congress agrees, it'll fund the transferring of the prisoner. So currently, transfers from Guantanamo are suspended, right? It's as a result of the war in Gaza and the expanding war in the Middle East, right? This past January, the chairman and the vice chairman of the Senate and House Intelligence Committees wrote to the directors of the CIA and the National Intelligence, insisting that funds available from the intelligence programs not be used to transfer prisoners from Guantanamo. And the reason they gave is because of the current of an alleged terrorism threat environment in the Middle East. So personally, I think this is a pretext to stop transferring prisoners out of Guantanamo, because really there's no real threat of recidivism by the prisoners when they're released. the Senate, including Senator Lindsey Graham, touts a 37% recidivism rate among prisoners released from Guantanamo. But that's faulty. Even according to the U.S. government's own standard statistics and findings, the recidivism rate as of, I think it was 2018, was 18%, and even that figure is high because of the way that terrorism is defined when they come up with these recidivism rates. According to the NGOs and the attorneys who represent prisoners who've been released, the recidivism rate is somewhere down around 7 to 9%, and that's of the past. I mean, of the people that are left there, I think it's even lower. So, but anyway, so yes.
I'm sorry, I don't mean to interrupt, and this may be for later, but there was also a sort of a cat and mouse game between Congress and the Obama administration a number of years ago with transferring prisoners to the U.S. for trial and stuff like that. At some point, if you could comment about that.
Yes, I'll say it now. In fact, in fact, I'll get to it in 3 slides. Okay, so hold on to that.
That's great. Thanks.
So, with respect to the 11 others that have been charged with war crimes, right? So remember, there's 30 prisoners at Guantanamo, right? 19 have been held without charge and indefinitely, and 11 have been charged with war crimes, and so they'll be tried by a military tribunal. So for those 11, the military tribunal is in the pre-trial stage, and in fact, it's only for 10 of them because one of them has already been convicted and is serving a life sentence in Guantanamo for conspiracy to commit a war crime. So with respect to the military tribunal trials, right, they're at the pre-trial phase because they're still determining whether to exclude evidence obtained by torture. So this is, 22 years after the tribunals have been established and after several Supreme Court rulings that have found the military tribunal's procedures to be unconstitutional, right? They're still trying to get their act together, and they're still determining evidentiary motions. So in March 2022, the military prosecutors offered a plea deal to the 5 prisoners among the 10 that are accused of planning the 9/11 attacks. Basically, if they pled guilty and provide information about the attacks, then they would serve a life sentence and the prosecutors would not seek the death penalty against them. The prisoners requested conditions for a life sentence, including that they not be subjected to solitary confinement during their sentence. They'll be allowed to eat and pray communally as they do now, and that they be given care for torture-related trauma, because some of these prisoners were waterboarded, for 80, 100 times and even more. They were subjected to torture at black sites for several years. So they all have trauma, severe trauma. The Biden administration rejected these conditions in September of 2023, and so they're still negotiating. We're not privy at all to the terms of the negotiation, other than what leaks out to newspapers, which is why journalism and following journalists with sources is a very important with respect to knowing what's going on in Guantanamo, because it's not just the lawyers that know things. Even the lawyers aren't told everything, and so journalists are an important part of the team. And some families of the 9/11 victims even oppose the plea bargain and want the prisoners executed. So post-release from Guantanamo. Prisoners from Guantanamo, to answer your question, Judd, by law cannot be brought into the U.S. Either released to the U.S. or brought to the U.S. for trial and imprisonment. That's by statute. They also can't be released to Yemen, to Syria, and to Somalia. Right, those are countries that they're not allowed to be released to. So usually, if you're not repatriated to your home country, you're sent to a third country, such as Serbia or Kazakhstan. And about 1/3 of the prisoners released from Guantanamo have been sent to third countries, not of their home origin. And in these countries, there's really a lack of a respect or understanding of the Muslim culture. And so what we find is that the released prisoners are subject to harassment. There's no respect for their culture. They're threatened with expulsion from housing and deportation. They're constantly monitored and restricted from traveling. And there's inadequate provision of medical care. Or in other cases, yes, there was a question there? Nope. Or in other cases, if they're not sent to a third country, they're sent to a third country and they're put in prison. For example, 18 Yemenis spent 5 years imprisoned in the United Arab Emirates after release from Guantanamo in 2016, where they were abused, tortured, and held in solitary confinement. I mean, they were asking to go back to Guantanamo, right? And then another person, Ravil Mingazov, who was from Russia, was released to the Emirates in 2017, and he's been held in solitary confinement since then. And now the United Arab Emirates threatens to send him back to Russia, where his life would be under threat. So the release from Guantanamo isn't always, a relief. For many, they were repatriated to their home countries, and they're getting along okay, but they're subject to various monitoring conditions. But for many others, it's been horrific. So with that, let me go back now to sort of a history and a chronology of how Guantanamo was established and how it came to be that people could be tortured there. So if you remember, right after the 9/11 attacks, right, the National Security Council met, and the CIA outlined plans for covert operations to fight, kill, and apprehend terrorism suspects and transfer them to black sites, to rendition them to black sites. On the 16th, right now, we're looking at 5 days after September 11th, right, and after the Security Council has met with the CIA, Dick Cheney gets on Meet the Press and states that the U.S. now has to work on the dark side, right? What has to be done in the shadows, right? And as he states, a lot of what needs to be done here will be done quietly, without any discussion, and we're going to have to use any means at our disposal to achieve our objective, which was for him to go round up as many terrorism suspects as possible. Coffer Black, the chief of the CIA Counterterrorism Center, put it bluntly when he testified before Congress about a year later. There was a before 9/11 and an after 9/11, and after 9/11, the gloves came off. So Coffer Black was the one who authored the unprecedented authorities, right? These extrajudicial means for the CIA to go conduct operations worldwide to capture suspected terrorists, right? This September 17th presidential memorandum of notification is the memorandum that grants the CIA the unprecedented authorities to, among other things, use significant discretion in determining whom to detain. Before that, the CIA didn't have a wide discretion to go after anybody. It had to seek approval beforehand. And another authority given was that the CIA could conduct covert operations without having to obtain formal approval for each specific operation, including renditions anywhere in the world. Lethal force was authorized for the CIA to assassinate people, including the use of armed drones, and the CIA could operate black site prisons. This presidential memorandum of notification, just for your background, a presidential memorandum of notification is a memorandum that the president issues to an executive agency, giving them authority to do something. And it's usually also copied to Congress. Here, it would have been copied to the intelligence committees. But this document still remains secret. It's still classified, even though many of the other memoranda related to Guantanamo and the torture there have been unclassified. So anyway, within a week, right, Congress passes the authorization to use military force. And that authorization was limited to the 9/11 attacks. Specifically, right, they authorized the president to use all necessary and appropriate force to go against those who planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th or harbored such organizations or persons. So the specific authorization by Congress, right, was limited to go after people who were connected with the 9/11 attacks. The people who were to execute this authority, right, who are going to govern or execute the global war on terror, were these five. Jane Mayer, in her book *The Dark Side*, which takes the name from Vice President Cheney's statement on Meet the Press, right, calls these five the War Council. They were David Addington, right, who was Vice President Cheney's chief counsel; Alberto Gonzales, who was the White House counsel; John Yoo, who was at the at the Justice Department's Office of Legal Counsel. The Office of Legal Counsel are the lawyers for the executive branch of our government. Tim Flanagan, who was the Deputy White House counsel, and William Haynes, who was the chief counsel, the general counsel for the Pentagon. So these five are the people who steered and made the decisions in the post 9/11 era on the global war on terror. And this group, as Jane Mayer documents in her book, were insular, right? They were unelected, and they were a self-reinforcing group because they all had the same, philosophy, and they had virtually no experience in the Muslim world. So I call them, for short, the legal architects of the global war on terror. So anyway, part of their philosophy and part of their execution of the global war on terror was to implement an expansive notion of executive power. Dick Cheney himself said, "I believe in a strong, robust executive authority, and I think the world we live in demands it." And earlier, when he and David Addington authored the Iran-Contra Minority Report, they wrote in it, in their minority report, that the president will on occasion feel duty-bound to assert monarchical notions of prerogative that will permit him to exceed the laws, right? In other words, that there are times when the president's authority can exceed the laws because we believe that the president in the Constitution has an expansive executive power. John Yoo explained the unitary executive in the memoranda to the president, that the idea goes back to Alexander Hamilton in, I believe it was the Federalist Papers, Federalist Paper number 70. Anyway, the way he interprets it is that the idea is that the Constitution, when it grants the president the executive power, it grants him or her a reservoir of executive power that's not specifically set out in the Constitution, that allows him to act as a leader and to enforce the laws in a time of emergency. So, this notion that the Constitution grants the president some reservoir of executive power that's not in the Constitution, like the sort of power by negative, is a theory that's really, an opinion. It's not accepted among most constitutional scholars, and it's based really on Yu's interpretation of the Federalist Paper and the constitutional debates, which really don't stand up to scrutiny. So anyway, based on this sort of notion and philosophy that the president can exceed the laws in times of emergency, because that he has the power to do that as the commander in chief and as the president, the White House interpreted the president's military powers broadly to reach beyond the authorization to use military force. In other words, that the president could go after any terrorist anywhere in the world and any terrorist organization under the authorization to use military force, whether or not they were linked to the incidents of September 11th. Well, this was in John Yu's memorandum of September 25th of 2001 to the president on the president's constitutional authority, where he discusses this notion of the unitary executive or the expansive powers of the president. So based on this, a military order was issued by the president, and in that order dealt with the detention, treatment, and trial, right, of non-citizens in the war against terrorism. And in this order, the president ordered that anybody who had been captured so far by any agency of the United States would be turned over to the control of the Secretary of Defense. And most importantly, these individuals would not be privileged to seek any remedy or maintain any proceeding in any court of the United States or in any state, right? In other words, we've captured you. You're going to be placed under the control of the Secretary of Defense, and you don't have a right to go to court to challenge, your detention. You have no right to habeas corpus. Of course, this military order isn't exactly correct because not everybody was turned over to the control of the Secretary of Defense. The CIA for several years kept people who had been captured under their control at these black sites, but that was a secret program that nobody was supposed to know about. And the scope of the people who could be detained under this military order was as broad as the notion of the executive's expanded power. Individuals subject to detention, right, included not only a member of Al-Qaeda, but anyone who engaged or aided or abetted or conspired to commit any acts of international terrorism, right, that affected the United States or any of its citizens or caused injury to them, or anyone who knowingly harbored one or more individuals, right, described above. So what you have is an interpretation of the authorization to use military force that exceeds what Congress authorized, right? Because of this expansive notion of the president's power, and this is embodied now in the executive orders that are setting up procedures to capture, detain, and try individuals, in the global war on terror.
Frank?
Yep.
In that military order, were there any definitions of international terrorism?
No, there were not. What I've underlined in this is the closest you'll ever get, and obviously international terrorism isn't defined. It's just construed. That's part of it, but this is vague. I mean, look at condition 3. What does it mean to knowingly harbor one of these individuals? It's not defined.
Wait, the question is the knowingly harboring or knowingly harboring knowing that they've done one of those things?
Well, I don't know. It could be either. And harbor and harbor itself is a vague term. We can intuit what knowingly means, right? Or you don't, or you turn a blind eye, let's say. But harbor, what does it mean to harbor? So my guess is that if push came to shove, this executive order, they would go to the definition of international terrorism that's in the statutes, in the U.S. Criminal Code. It's Title 18 of the U.S. Code. And that's where you would find a definition of international terrorism. And that's probably what they would use as the definition. Okay, can I continue?
Continue.
Guantanamo was selected as the place to hold these prisoners now that they're gathering, that they're amassing, right? Because the U.S. believed that courts could not exercise habeas jurisdiction there, right? So in this other memorandum, right, from John Yoo, right, to William Haines now at the Department of Defense, right, the General Counsel at the Pentagon, right, Yoo concludes that the great weight of legal authority indicates that a federal district court could not properly exercise jurisdiction, right, over an alien detained at the Guantanamo Bay, prison at Guantanamo Bay, right? And I don't go into this in these slides, but since you're a small group, I'll just give you a bit more background on this. So this conclusion is based on a territorial notion of jurisdiction. In other words, courts, the U.S. courts only have jurisdiction over events and people that are in a U.S. territory. And so you didn't consider Guantanamo to be a U.S. territory because it was in Cuba, right? And so, unfortunately, he was wrong because the extent of the U.S. jurisdiction can be extraterritorial, and the Supreme Court in 2004 overruled this notion of jurisdiction just in the territory of the U.S. The court ruled specifically that Guantanamo was, for all practical purposes, a U.S. territory, and therefore the prisoners that were the foreigners, the foreign prisoners that were being held there, right, were entitled and therefore the statute allowing habeas corpus review to prisoners extended to the prisoners at Guantanamo who were not citizens. And the reason there's a distinction between citizens and foreigners is that if you were captured in Afghanistan and you were a U.S. citizen, like what was his name, John, I forget his last name, you would have constitutional rights because you're a U.S. citizen, and so you would have due process rights, among other things, and you would need to be tried by a jury, et cetera, et cetera. But if you're not a U.S. citizen, you're an alien or foreigner, those rights may not apply to you or don't apply to you. The U.S. courts are still split on whether or not aliens, who are captured and held by the U.S. On U.S. territories, right, on U.S. bases, have constitutional rights. And so that's the debate. So that's one of the debates going on back and forth between the courts and the executive and the executive departments, the military and the Pentagon, right? The other debate and you should already that I've been trying to explain is the constitutional powers arguments or the separation of powers arguments, right? What you have is the Congress and the president in a tug of war between the extent of the president's powers, right? The authorization to use military force is a result of the War Powers Act that was enacted after the Vietnam War, right? So then the Congress, didn't want, the president going around conducting wars at will. It wanted to limit the president's powers. So they enacted the War Powers Act, which required the president to notify Congress if U.S. troops were going to be committed more than 60 days in any one area, and the president had to get authorization from Congress to do so. Another result of the Vietnam era were also setting up the intelligence committees in the Congress to monitor the CIA so that they don't go around assassinating people. So anyway, so you have these two debates going on, right? The extent of the president's powers under the Constitution and the tug of war between Congress and the executive, and then you have this other debate about exactly what rights do foreigners have when they're imprisoned by the U.S. outside of the U.S. So what is Guantanamo, right? Well, Guantanamo is really an outpost of the U.S. empire. And, this is a sign that's at Guantanamo. And I think more than anything else, it shows why Guantanamo can be considered a U.S. territory. It's got the flag planted right there. The U.S. leases Guantanamo from Cuba, right? After the Spanish-American War, the U.S. held on to Guantanamo Bay. And per a 1903 lease that was, renewed in 1947, the U.S. can use Guantanamo as a coaling or a naval station, right? The lease is in perpetuity, and the annual rent payment is about $4,000, which the Cubans, after Fidel Castro took control of Cuba, they don't accept. They send it back to the U.S., and so it sits in some fund somewhere. And although, according to the lease, Cuba exercises ultimate sovereignty over Guantanamo, but the U.S. exercises complete jurisdiction and control over and within Guantanamo. And it was this phrase in the lease, complete jurisdiction and control over and within Guantanamo, that the U.S. Supreme Court in its decision cited as saying that this is why they consider Guantanamo to be a U.S. territory for all practical purposes. So Guantanamo had been used previously in the early 1990s to hold Cuban and Haitian refugees. And I don't know if you've seen or read recently, it's been raised again that because of the situation in Haiti, the administration is considering sending Haiti refugees to Guantanamo. Of course, they're not held in the prison where the where the prisoners are held. That we represent, that I'm speaking about. They're held in open areas that are fenced on various parts of the island. I think it's important to know that Guantanamo has a history of trading in captives and in captive bodies. Guantanamo was a slave port in the transatlantic triangle. Slaves were taken from West Africa and sent to Cuba, where they were, made, sold and made to work in the sugar plantations in Cuba. And there's even a more direct connection, which is that the same British company that made the shackles for the slaves during the transatlantic slave trade also makes the shackles for the prisoners at Guantanamo. The name of that company is Hyatt and Hyatt and Company. It's a British company. And, it was discovered by the lawyers who noted the name of the company on the shackles and then doing research to find out what the history of the company is. All right, so who was supposedly sent to Guantanamo, right? The narrative of Guantanamo, right? So according to Secretary of Defense Donald Rumsfeld, Guantanamo would house the worst of the worst, right? According to the Chief of Staff, General Myers, right? The people at Guantanamo were people who would gnaw through hydraulic lines in the back of a C-17 to bring it down. Guards were told that the people at Guantanamo they'd be guarding were known terrorists, that many of them helped the planning of the 9/11 attacks, and that they would be coming face to face with the worst people in the world. And so, according to this guard, right, many of the guards were mad, were annoyed, and they wanted to get revenge for what happened to the U.S. So you can just imagine, the kind of atmosphere that was created by telling the guards and all of the U.S. personnel there that the people who were coming to Guantanamo were the worst of the worst who had planned the 9/11 attacks, right? And what kind of situation would occur in terms of the violence that could be inflicted on the prisoners. Same from an Arabic translator, Sergeant Eric Saar, right? Again, our government had said, they would be the worst of the worst. And I took that to mean the individuals had extensive training from Al-Qaeda. Additionally, I thought that they were the people who planned the 9/11 attacks. But who really was sent to Guantanamo, right? Who really was sent there? I've already explained that 86% of those sent to Guantanamo were sold to the U.S. for bounties. They were sold by warlords claiming that these people were Al-Qaeda or were terrorists, when in fact they weren't. They weren't at all. They were just people who were in Afghanistan or Pakistan at the wrong place at the wrong time. Or if they were with Al-Qaeda, they were just a bunch of privates or sergeants. They certainly weren't generals or high officials. So, and it didn't take long for the people working at Guantanamo to realize that these people were nobodies, right? But according to, the MP, Brandon Neely, as the months went on, one or two of us would actually question what was going on here, the way the detainees were being treated, as if they were actually terrorists, but really they were no ones. They were just young and dumb. I mean, think about it. Some of the prisoners were as young as 14 years of age, 14 years of age. And really, these were the worst of the worst, right? Even Rumsfeld had to acknowledge that Guantanamo was being populated with low-level people, right? In a memorandum he sent to the Joint Chiefs and to the Central Command commander, just a little bit more than a year after Guantanamo opened, he says, we need to stop populating Guantanamo Bay with low-level enemy combatants. Yeah. According to the Muslim chaplain, James Yee, right? I mean, what was happening was that the detainees were being interrogated relentlessly, right? For information that they didn't have. And the guards were saying, look, just tell us something that we have to take back to our supervisor. So a little bit more background about this because we're a small group. So what's happening is that the U.S. is capturing all of these people in Afghanistan and Pakistan and now elsewhere. And it wants to obtain as much information as possible about any alleged terrorist attack on the United States. So it's not anymore even about capturing the people who planned 9/11 or capturing high-level terrorists, right? That's the fake narrative. What's happening is that they're just rounding up anybody they believe is suspected of terrorism, and they're questioning them ad nauseum. And then once they finish questioning them, either because the person has told them everything they know, or the person doesn't know anything because they have nothing to do with terrorism, which was the majority of the captives, they keep them there. They can't let them go because then they would lose face. The U.S. would lose face. It would show the hypocrisy of the U.S. So James Yee was a captain. He was a Muslim. He was the Muslim chaplain at Guantanamo, and he stood up and he said, "Look, you're treating the prisoners wrong, and you've got to stop these people. They're not the terrorists you think they are." And what happened to him was that he was accused of aiding terrorists. He was arrested. In fact, a hood was put over his head. He was shackled, and he himself was accused of being a terrorist. And it took him 10 years to clear his name. So Shakir Amr is a Saudi citizen and was a British legal resident. He was imprisoned in Guantanamo without charge, for about 14 years. He went to Afghanistan to help people suffering from the war. He had gone to Pakistan with his family, and then he went to Afghanistan once the war started to help the people who are suffering, because part of the duty of Muslims is to perform charity. And so he was performing that duty, right, of his religion. So he was kidnapped by warlords and then sold to the U.S. for a bounty. So what I'd like to do is play a clip of an interview of him by the BBC. It's a short clip where he discusses his interrogation by an interrogator who accused him of plotting or being part of the 9/11 attacks. And Shakir says, "I didn't know anything about them and I had nothing to do with them." So I'm going to have to stop sharing and then share again. Okay. Right. I gotta go to, here.
What are they asking you?
One of the incidents really, I can't forget.
Can you hear this?
Yes.
Okay.
Yes.
Okay, good. I'm sorry. All right. So hold on. Let me just open this.
Because I don't know much about 9/11. Truly, I don't know much about it. I don't know, what happened there truly. So for me, it's just like, okay, two building collapse, And one day I was in an interrogation, and the interrogator brought a book, and it has all scenery from 9/11. And then he kept opening, one page after another page. And then suddenly he stopped on a page where somebody jumped from all the way up, God knows, 100th floor or something. And he's jumping, running away from the fire. So I looked at it, and in my mind, the guy is going to get killed by fire. But he knows when he jumps, he's going to get killed anyway. So I start crying. And he looked at me, he couldn't believe it. He's crying. So he grabbed that huge book and he just picked it up and smacked it on the table. And he looked at me, "You crying? You did this?" I said, "I didn't do nothing, man. Why do you think I did that?" And that's why I felt they really, they don't want to even believe you are a human being. They don't want you to feel that, yeah, I'm just a man with feelings, just like you. But they don't want to believe that. And when they get to these moments where you show them that you have feelings just like them, they hate it because they know what they are doing to you.
So what were these what were these interrogation techniques that were going to be performed on all of these people, all of these prisoners now who were being rounded up and sent to Guantanamo and even to the black sites? So, right, the military, right, looked to its survival, evasion, resistance, and escape interrogation techniques, right, in order to get information from all of these prisoners, right? The SEER program is a program that teaches trainees how to withstand counter-coercive interrogation, right? It subjects U.S. military and civilian special operators to coercive interrogations as part of a survival course. The interrogations are based on techniques used on prisoners that contravene the Geneva Conventions, particularly techniques used against U.S. prisoners in prior wars, right? And so these interrogation techniques include waterboarding, stress positions, nakedness, hoods over the head, sleep disruption, exposure to loud music and flashing lights, and exposure to extreme temperatures. The SEER methods, right? These interrogation methods are an outgrowth of studies done in the 1950s of the most efficient way to break down a prisoner during interrogation and to have them give you information. And that information was put together in a manual for the CIA called the Kubark Counterintelligence Manual, right? And the significant findings of these psychological studies that were produced in the Kubark Manual were that the deprivation of sensory stimuli and self-inflicted pain are the two most efficient methods when taken together to break down a prisoner and have them begin to tell you information, right? With respect to the deprivation of sensory stimuli, right? The manual says the chief effect of arrest and detention is to deprive the subject of as many or most of the sights, sounds, tastes, smells, and tactile sensations that he or she has grown accustomed to. And with respect to pain, right? Resistance is likely to be sapped by pain, which he seems to inflict upon himself, right? When the individual is told to stand at attention for long periods, right? An intervening factor is introduced. The immediate source of pain is not the interrogator, but the victim, right? And so the motivational strength of the individual is likely to exhaust itself in this internal encounter because the pain is self-inflicted. This picture, it's a picture that's often shown of the Guantanamo prisoners. It's the first number of prisoners taken to Guantanamo on January 11th, 2002. And they were taken to Guantanamo and then sent to Camp X-Ray, and this is how they were dealt with. You'll see that they're all being deprived of sensory stimuli. They're wearing hats. They're wearing goggles that are darkened. They're wearing earmuffs. They're wearing gloves, and they're wearing respirator caps over their mouths, as well as they're undergoing self-inflicted pain because they're kneeling on a rocky ground. So this is exactly what the Kubark Manual instructs, and this is what the military put to use at Guantanamo. So in order to come up with the proper techniques to interrogate all of these prisoners, the military and the CIA, they hired two former SEER psychologists to develop, what are called euphemistically enhanced interrogation methods. And both of them, they were paid $81 million for their services. There were obstacles, however, to the U.S.'s plan to interrogate all of these prisoners. To begin with, the Geneva Conventions presented an obstacle. The four Geneva Conventions, just for your background, and their protocols establish humanitarian standards in armed conflict for the treatment of prisoners of war, civilians, and other injured or stranded soldiers and sailors. The Geneva Conventions were ratified by the U.S. in July of 1955, and they are codified in U.S. law, right, as the War Crimes Act. So the first obstacle is the third Geneva Convention, which is on the treatment of prisoners of war, right? So the Third Geneva Convention applies in international armed conflicts, which is basically a conflict between two nation states, as we see, for example, in Ukraine and Russia, right? So under the Third Geneva Convention on POWs, right? POWs must at all times be humanely treated and protected, particularly against acts of torture, violence, intimidation, and medical experimentation. They have to be free to exercise their religion. They must receive fair trials and punishment, and they have to be released and repatriated upon the cessation of activity of hostilities, active hostilities. So the loss of rights if you're deemed not a POW. So if you're deemed not to be a POW, right? If you don't meet the definition of a POW, then you lose those protections under the Third Geneva Convention, but you're still protected under Common Article 3 of the Geneva Conventions, right? The Geneva Conventions have two common articles. One of those common articles in all four conventions is Common Article 3, right? And so that Common Article 3 presented the second obstacle. Common Article 3 applies in non-international armed conflict, which is basically a conflict between one state, right, a member state that signed the treaty, and a non-state actor. Under Common Article 3, right, it prohibits cruel treatment and torture of persons taking no active part in the hostilities, including those who have placed their arms down and are detained. So without the protection of Common Article 3, prisoners that are not POWs could be abused because there's no protection for them under the Geneva Conventions. The third obstacle is the War Crimes Act itself, right? Because it provides for prosecuting those abusing prisoners. So under the War Crimes Act, right, if you commit a war crime, which is defined as a violation of any of the common articles of the Geneva Conventions, right, and you're a member of the U.S. Armed Forces or a U.S. national, you're going to be subject to prosecution, prison, and potentially the death penalty. So these presented obstacles to the administration because they wanted to interrogate the prisoners, and they wanted to interrogate the prisoners with impunity. They didn't want anybody at the Defense Department or the CIA or the FBI who was interrogating the prisoners to be subject to the War Crimes Act. And they wanted their methods of interrogation not to be prohibited by any of the provisions of the Geneva Conventions. So they asked the Office of Legal Counsel for a memorandum. And John Yoo, in a memorandum dated January 9th, 2002, which is 3 days before the first batch of prisoners arrived at Guantanamo from Bagram Air Base, he issued this memorandum, and in it he argues that the Geneva Conventions and the War Crimes Act do not apply to the prisoners at Guantanamo. And so this memorandum, right, it argues that, well, with respect to Al-Qaeda members aren't covered by the Geneva Conventions because they're a non-state. They didn't sign the conventions. Also, Al-Qaeda members aren't prisoners of war, but they're unlawful enemy combatants, right? A term that you made up there in the memorandum because they are neither regular armed forces nor qualify as the regular armed forces under the convention. And the conflict with Al-Qaeda is not a non-international armed conflict. And so therefore, Common Article 3 doesn't apply to the Al-Qaeda. And with respect to the Taliban, the Geneva Conventions don't apply to them either because the Taliban is not a government. Afghanistan is a failed state, and the Taliban are like Al-Qaeda. They're not POWs. So you can see that what's happening is that the administration is papering itself with legal opinions that really are disingenuous because for the reasons I'll give in a second, are papering themselves so that they could rely on these memoranda to say that what they did was legal. So use analysis of the Geneva Conventions and the War Crimes Act is based on a narrow interpretation of the Geneva Conventions. He narrows the interpretation of Common Article 3 as limited to civil war or insurgency within a state, and not to all forms of a non-international armed conflict, as the Geneva Conventions are interpreted by almost all international law scholars, as well as the International Committee on the Red Cross, which is the official interpreter of the Geneva Conventions. And use interpretation is based on a textual approach to interpreting the treaties. You limit yourself to the specific strict language of the treaty, and this is contrary to the interpretation of the Geneva Conventions by international humanitarian law scholars that interpret the Geneva Conventions broadly, not narrowly and textually. And it's the same kind of textual approach that conservative justices on the Supreme Court take with respect to the Constitution. Use analysis is also based on his theory of an expansive executive power, right? He states in his memorandum, any congressional effort to restrict presidential authority would, by broadly construing the Geneva Conventions, or one not borne by the text, would represent an infringement on the president's discretion to direct the military. He's raising again the separation of powers argument and his theory of the expansive executive. So use analysis of the president's power as the military commander doesn't comport with Supreme Court precedent on separation of powers, right? In Youngstown Sheet and Tube, right, 1952 decision by the U.S. Supreme Court, right? So in that case, President Truman seized the Youngstown Sheet and Tube Company factory, which made steel, and he seized it so that the steel made there could be used for the Korean War. So the seizure was challenged, and President Truman lost. Justice Jackson, who, by the way, was the chief U.S. prosecutor at the Nuremberg tribunals, he wrote, "No penance would ever expiate the sin against free government of holding that a president can escape control of executive powers by law through assuming his military role." In other words, look, the president is subject to the law, and his military powers don't get him out of, being restricted and being ruled and having to obey the laws. So Secretary of State Colin Powell disagreed with you at the time of this memorandum of you stating that the Geneva Conventions and the War Crimes Act don't apply to the prisoners at Guantanamo, right? Powell asked President Bush to reconsider. He says, look, this notion, this policy reverses a century of U.S. policy and support for the Geneva Conventions. And also, we will be subject to legal challenges. And also, foreign prosecutors potentially may prosecute U.S. officials and troops based on this theory. But Presidential Counsel Alberto Gonzalez, right, urged Bush, advised him not to reconsider his decision, that the prisoners are not POWs and that the Geneva Conventions don't apply. And he in his memorandum, he basically gave two reasons. The first one was to preserve flexibility in the war on terror. In other words, to obtain information quickly from the people who are captured. And secondly, and this is critical, it would reduce the threat of criminal prosecution under the War Crimes Act, right? He says specifically, a determination that the Geneva Convention is not applicable to the Taliban would mean that the War Crimes Act would not apply to actions taken with respect to the Taliban. In other words, with their interrogation, or the fact that the prisoners were put in black sites. Even the Attorney General, Ashcroft at the time, also advised that the prisoners not be protected by the Geneva Conventions, and it was for the same reason, right? It would provide the highest assurance that no court would subsequently entertain charges that American military officers, intelligence officials, or law enforcement officials violated the Geneva Convention rules relating to detention and interrogation, right? And the War Crimes Act, right, would not apply, or if it did, it would be a crime. So, to me anyway, the real reason for not having the Geneva Conventions apply to the prisoners was basically to allow for this kind of interrogation that amounted to torture, and to be able to do so with impunity by the officials who were doing it. And this is borne out in all of these memoranda that I'm quoting. But there was also a fourth obstacle to the US's plan, and that was the UN Convention Against Torture, right? So in addition to the Geneva Conventions, there's a Convention Against Torture, right? And the Department of Defense and CIA were concerned that interrogating the prisoners with these techniques would lead to prosecution under the Convention Against Torture and its corresponding US law. right? The excuse me, the Convention Against Torture defines torture as an act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person in order to obtain information or confession, basically, right? And U.S. federal law, right, which codified the U.S.'s signing of the Convention Against Torture, follows the same definition. Torture means an act committed by a person acting under color of law, specifically intended to inflict severe physical or mental pain or suffering. So, in order to get around this obstacle, again, the excuse me, right, the Office of Legal Counsel was asked to issue a memorandum about whether or not these interrogation techniques can be considered torture under the Convention Against Torture and the corresponding U.S. law. By this time, John Yoo had left the Office of Legal Counsel. I think President Bush made him a judge, a federal judge out in California. And so what you had was a memorandum by Robert Bybee, right, to the White House. So just like with the Geneva Convention memorandum, in this memorandum to the White House, right, the Office of Legal Counsel narrowly interprets torture, right? Specifically, it now defines torture as a specifically intended to inflict severe physical or pain or suffering. It must be of an extreme nature to rise to the level of torture, right? It has to be tantamount to organ failure, impairment of bodily function, or even death, right? So what they've taken is they've taken the adjective severe and they've replaced it with a definition of extreme. And in that way, they narrow the definition of torture. So the Bybee memo to the White House is also based on this expansive notion of presidential power, right? Bybee writes in the memorandum, and this memorandum now is dated August of 2002. The president's power to detain, right, and interrogate enemy combatants derives from his or her authority as commander-in-chief, interpreting, right, the corresponding U.S. law prohibiting torture in a manner that regulates how the president can interrogate prisoners would raise constitutional issues, right? And then they hedge their bet. Even if the interrogation methods violated, the U.S. law, they are justified by the defenses of necessity and self-defense to elicit information to prevent a direct and imminent threat to the U.S. and its citizens. At the same time that Bybee wrote the memo to the White House, he also issued a secret memorandum to the CIA that used the same narrow definition of torture. The secret memo to the CIA, which has been disclosed and unclassified, right, had to do with a request by the CIA about whether or not the interrogation of Abu Zubaydah would violate the Convention Against Torture and the U.S. corresponding law, right? At the time, Abu Zubaydah had been captured. He had been captured in Pakistan. He had been shot and almost died. And in fact, the U.S. flew a surgeon from Johns Hopkins here in Maryland to Pakistan to operate on him to keep him alive. And Zubaydah was from Pakistan, sent to black sites, first in Thailand and then in Poland, where he was, where he was tortured. In August of 2002, he was subjected to waterboarding 82 times. So 82 times in a month. At that time, excuse me, the U.S. thought that Abu Zubaydah was the number 3 in Al-Qaeda. He was the number 3 official after Osama bin Laden and Zawahiri. But he wasn't. And the FBI several years later admitted that he wasn't even a member of Al-Qaeda, and in fact, that he was a person who suffered from bipolar disorder. So the Bybee memos were reaffirmed 3 years later by Bradbury, who was then at the Office of Legal Counsel. He reaffirmed in memoranda to the CIA that the definition of torture, as Bybee had done in his memo, still was valid. Severe physical pain denotes physical pain that is extreme in intensity and difficult to endure, and it's reserved for unusually cruel practices like systemic beatings, application of electric currents to sensitive parts of the body, tying up or hanging in positions that cause extreme pain. So again, the adjective goes from severe to extreme. So the Bybee and Bradbury memos to the CIA compare the experiences. So in concluding that the interrogation techniques that were going to be used on Abu Zubaydah were not torture, the Bybee and Bradbury memos to the CIA compare the experience of trainees undergoing the SEER interrogation methods against their narrow definition of torture. And the memos conclude that none of the interrogation methods amounts to torture when properly conducted and monitored. And the memos assess the interrogation techniques in a sanitized and ideal manner. For example, the memo with respect to, let's say, walling, right, which is one of the interrogation techniques, the memorandum states, this technique involves the use of a flexible false wall. We understand that this technique is not designed to and does not cause severe pain, even as used repeatedly as you have described. But the reality was, as Shakir Amar said, you know, there wasn't any false flexible wall. Behind me, there was a concrete wall. Somebody just grabbed my head and started smacking it to the wall behind me, back and forth, pain after pain. And all I'm trying to do is protect my head. So nothing was done in a sanitized way that these memoranda analyzed the interrogation techniques. It's the same with stress positions, right? The memorandum assessed 3 stress positions, right, that were supposed to be at certain angles for a certain duration of time, and concludes that, you know, as with wall standing, we understand that these positions are used only to induce temporary muscle fatigue, right? But the reality is different, right? So here, right, Razak Ali talks about how he was shackled in extremely painful positions. They would leave him like that for hours and then come in and scream and hit him, asking him questions. The interrogators wanted me to admit that I had been fighting in Afghanistan and that I was a part of Al-Qaeda, and neither was true, right? I mean, what information could he tell them when he didn't know anything? This is a drawing by an artist of the short shackle. It was a shackling that was used on the prisoners at Guantanamo, and you know, testimony by the prisoners there is that they were kept like this for days, you know, for more than a day, right, for 24 hours. It was never of short duration, and so this is one of the common stress positions. And another form of torture that really isn't highlighted, that I want to just bring your attention to, is force feeding, right? I mean, you can imagine that because of the conditions at Guantanamo, the prisoners started to go on hunger strikes. They went. There were 3 periods of hunger strikes in 2005, 2007, and 2011, right? And so, you know, as the prisoners discuss it, you know, they were tied to the bed, right? They spent 26 hours in a state. They were force fed, and they weren't even allowed to go to the toilet, right? And when the feeding tubes were put into their noses, it was done painfully, and it was pulled painfully. Sami El-Haj was a Sudanese journalist who worked for Al Jazeera. He was held at Guantanamo without charge for 6 years. The only journalist held at Guantanamo. He was captured or sold by warlords, really, to the U.S. authorities on the claim that he was Al-Qaeda's propaganda PR person, because as a journalist and as a cameraman for Al Jazeera, he had taken part in an interview of Osama bin Laden. So anyway, so he went on hunger strike in 2007, and he hunger struck for 438 days without food, and he was subjected to force feeding. There are interviews of him that you can find where he talks about this, but he is the one who wrote the poem, Humiliated in the Shackles, that I quote in the first slide introducing this presentation, where he says, I am a captive, but the crimes are my captors. Also, just to mention that there was institutionalized Islamophobia at Guantanamo, right? The techniques of punishment and torture specifically weaponized the prisoners' religious beliefs. So Dr. Hilal writes about this in her book, but basically, right, there was an interfering with prayer. There was a ridiculing and a mocking of the call to prayer. Korans were thrown in the toilet and otherwise desecrated. They were made, the prisoners were made to bow in a dark room before a satanic circle. Their facial hair was shaved, and they were made to stand naked in front of female guards. All of this is, taking the morals of the Muslim religion and using it against them at Guantanamo. This is another drawing by the same artist of what was known as the Guantanamo haircut, where the facial hair of the prisoner was removed. So the legal framework implemented by the executive allowed for the torture of prisoners at Guantanamo, right? The captured prisoners, suspected terrorists, were not subject to the protections of the Geneva Conventions or the Convention Against Torture for interrogation, detention, and treatment of prisoners. They were not allowed access to U.S. courts, and they could be tortured by U.S. persons with impunity. And so, as Major General Joffrey Miller, the commander at Guantanamo prison, told General Kaprinsky, who was the commander at Abu Ghraib, the prisoners are like dogs, and if you allow them to believe at any point that they are more than a dog, then you've lost control of them. So they treated the prisoners like animals, and that's why you have torture at Guantanamo, a legal framework and a mentality that disregards the humanity of the prisoners and the law that is supposed to regulate the course of conduct in war and in detention. So the CIA's use of these interrogation methods was not effective in acquiring intelligence or gaining cooperation of the prisoners. The Senate Intelligence Committee report on torture concludes that the CIA's representations that intelligence provided thwarted attacks on the U.S. were inaccurate and unsupported by the CIA's records. And what were the results of the global war on terror? Well, what we have, and this is from the Watson Institute at Brown University that conducted studies. The direct deaths attributed to the global war on terror were somewhere between 897,000 and 929 million people killed in Afghanistan, Pakistan, Iraq, Syria, Yemen, and in other places. And of course, then you have indirect deaths. Its study estimates that there were between 3.5, 3.8 million indirect deaths resulting from the post 9/11 wars, destruction of economies, public services, the environment, and the spread of disease. And the amount spent on the global war on terror, as at the end of 2022, was somewhere around $8 trillion. And so you can imagine how $8 trillion could have been better spent in this country. Not to mention to reduce the size of the U.S.'s debt, but in our communities, for better healthcare, better education. So I want to just wrap up, if you can still stay with me, that I want to just bring attention that Guantanamo is just not in Cuba; it's also in our own backyard. So the U.S. federal prisons have something called special administrative measures, which are a form of isolation, of sensory deprivation, that are imposed on prisoners on top of solitary confinement to seal off the prisoners' avenues of human contact and communication. These special administrative measures include physical isolation, social isolation. You're restricted in light. You're restricted when you're allowed out of the cell. You're restricted with whom you can communicate. Spiritual isolation, where there's a restriction on your ability to practice religion. And information isolation. You're restricted to access to information about the outside world, right? This is a measure of sensory deprivation and social isolation that is similar to what the Kubark manual discusses and what was happening in Guantanamo. There's the issue of teams of officers beating up prisoners, right? On November 9th, 2022, according to the New York Times, the corrections emergency response teams from other prisons converged on cells over 2 days at Sing Sing prison in New York, ordering prisoners to strip to their boxer shorts and then punching and kicking and slamming their heads against the walls, right? According to the affidavit, 26 inmates, right? So this is similar, right? to what was going on in Guantanamo when the military police would barge in to the cell to extract the prisoner. You know, it was called softening the detainee for interrogation. In addition, note the position of the knee, right, on the back of the prisoner, right? This is Derek Chauvin, right? Derek Chauvin has his knee on the back of George Floyd, right? It's the same position. And it's not, it shouldn't be any surprise because Derek Chauvin was actually a military police officer when he was in the military. So that's where he learned this position. He wasn't at Guantanamo, but he was in the MPs. And so, you know, these techniques that are taught to the military, you know, come down to the police, just like all of these surplus weapons from the laws, right, are then transferred to the police to militarize the police here in the US. Another way that Guantanamo is in our neighborhood is you have, you know, during the Black Lives Matters protests, you had undercover Customs Border Patrol agents in Portland, Oregon, abduct demonstrators, right, and take them to unmarked vans for detention. Right? So it's, I mean, you know, and then in addition, you now have in the federal prisons force feeding, right? According to the Bureau of Prisons data, there were 84 force feedings between 2010 and 2022 at the maximum security facility in Colorado. And, you know, this force feeding, again, you know, like similar to what was happening in Guantanamo, is you know, violent. And can be considered a form of torture, especially when it's against the prisoner's, you know, will. And lastly, and I'll wrap up with this. The Guantanamo is also not in Cuba and in our backyard. It's also around the world. So in the Israeli-Gaza, right, wars, right, the administrative detention of Palestinian prisoners by Israel has skyrocketed since the war started in the aftermath of the October 7th attacks, right? This data is as of November 2023, and I'm pretty sure that I couldn't find anything more recent. But you know, testimony from released detainees and human rights lawyers, as well as video, right, talks about forms of torture by Palestinians who have been captured by Israel in the Gaza war. I mean, they're treated like the prisoners were in Abu Ghraib and in Guantanamo. They're stripped naked, they're blindfolded, and they're taken to secret prisons. You know, there are severe beatings and humiliation. There's kneeling for extended periods of time. You know, some are made to sing Israeli songs, just like prisoners at Guantanamo were made to sing the American national anthem, right? One prisoner, right, Jihad Hamouda, says that he spent 17 days blindfolded and handcuffed in an Israeli detention facility, made to kneel on the ground for hours at a time. We wouldn't know when he was going to be released. Northeast Syria is another place. There's 47,000 refugees in the Al-Hol and Raj camps. These were mostly women and children who were the wives and children of ISIS fighters who have been killed in the war in Syria. And you know, these refugees are detained in facilities. They're not. Many countries won't allow them to be repatriated, and so you know they're living in conditions where they can't appeal. You know, their detention. They can't be brought before a court, and so you know they're basically being held arbitrarily and indefinitely. It's another Guantanamo. And Libya. So refugees from sub-Saharan Africa flee to Europe across the Mediterranean, are remotely tracked by the Italian police who contact the Libyan authorities. The Libyan authorities then interdict the boats. And if they don't, you know, capsize and drown the refugees, they take them and they imprison them in a prison in Tripoli, the Al Mabani prison. If you pay 2,500 Libyan dinars, you might get released, and no one knows you're there. No one knows you're there until you make a payment. The prison is controlled by a militia. So this is, again, another, you know, arbitrary detention, prison. And there's many more around the world. I'm just giving you some of the more major ones. You know, like I said, I'll make this slideshow available, but there are resources and organizations that you can consult to find out more about Guantanamo. There's a whole list of books that one can read. And so, you know, we continue, we lawyers and we journalists and we activists continue to try and close Guantanamo and to get the prisoners, at least who have been, cleared for release, to be released from there. So, and I hope you're still with me. And if you are, thanks for, God, that was long. I'm sorry. I went on for 1.5 hours, but anyway.
That was great, Frank. We are still with you.
If anybody has any questions, I'm happy to answer.
I just had a quick one. Did you have to sign agreements to be able to go to Guantanamo and represent?
Yeah, you do. You have to get a security clearance. I had to apply to the government for security clearance, and you have to get a secret security clearance in order to look at the information. Yeah. That's why I can't really talk a lot about some of the details about the guy who I represent.
Right.
Yeah.
That's what I figured.
Yeah. Yeah, and you can't even go to Guantanamo unless you have a security clearance, unless you're a journalist, in which case journalists are taken to Guantanamo. They're given a tour that's handled, by the military, so they're only allowed to see whatever the military wants them to see. Whereas as a lawyer, I have more reign. I have more free reign over where I can go, and obviously I can talk to the prisoners and I can go inside the prison itself.
I have two quick questions. The first one is, have a lot of the legal precedent that you talked about, has any of that been rolled back in the United States, either by legislation or by judicial? Because I so much of that was just the expansion of executive powers. I just wonder, has any of that been changed since the ineffectiveness of torture and all these other things have been brought to light? So I guess that's the first. Yeah. Do you know of anything that has changed on that front?
Right. I haven't, because, and I think that, so I think this debate is going to go on as long as there's a United States and a Constitution. And right now, the Congress is in bed with the president on this issue. So there's no reason to contest the expansive powers of the president. But if a situation arises where the president, does something that the Congress doesn't think doesn't agree with, then you would see this come back and there'll be a tug of war again. Of course, like at the end of the Vietnam War era, Congress was at the height of its powers vis-a-vis the president, because of the conduct of the Vietnam War and the uncovering of what the CIA had been doing for all those years. So I don't know if that'll ever happen again in the U.S., but of course it may. But right now it's not, and it hasn't been taken back because both branches agree, and it seems the Supreme Court doesn't really want to deal with it as well. But it could happen in the future.
Yeah, and then the second question was on the Geneva Conventions on torture. Have any Western nation ever been held culpable by those conventions? Like, is there any precedent of like a UK or a Canada or some Western country being held to those standards?
I think there is, but I don't know offhand. I'm thinking of the president of Liberia and some others, but I don't know, because you have an international criminal court now that can prosecute people for war crimes. It's so, and that would be under a different treaty, although it may include the Geneva Conventions. So I don't know offhand. I certainly, I could look and see and get back to you on that. Yeah.
Thank you.
Is the snow piling up there in Maine? Yeah.
It's still snowing a little bit, and it's supposed to get worse tonight.
Well, look, if anybody else have any questions,
Frank, one thing, I'm sorry, was somebody else starting to speak? It's not a question, it's just a kind of a thought that keeps coming up as I listen to all of this. One was the recent discussion of sending people, Haitians and people up from our border to Guantanamo. And I realize it's not the prison, but still, I mean, what kind of I just can't imagine what people would do if they were there. I mean, how would they survive? And you said that there's open spaces and whatever, but would people just be dumped there? I mean, that's one of the things that sort of a
Yeah.
peripheral.
Yeah, Denny, no, thanks. It's a dumping ground. I mean, they would be put in tents. I mean, obviously, there's no housing facilities like you're thinking of a house. So they would be put in tents and then they would be given, meals, meals, either military rations or whatever meals could be gotten together. Or, if Jose Anders, was able to get there, he would bring, his meals through his operation. But, and I think that's how it was in 1994 when, in the early 90s when the Haitians and the Cuban both people were sent there. The U.S. has this thing about not allowing refugees on its, into this country, keeping them out as much as possible. So, of course, the Guantanamo is not huge. There's a limited amount of space. So I don't know exactly how many refugees could actually be sent there. Certainly it couldn't be as large as the camps in Northeast Syria, which are like really expansive. So,
Yeah. The other thing that just kept coming up all the way through for me, and you did touch on it at the end there, is what happens to the people who do this torturing and whose minds are changed to look at people as less than human? And, what does that mean? And you mentioned Frank, what's his name? I'm sorry. Derek, what's it? Derek
Chauvin.
Yeah. And how many of those people are working in our prisons and jails? And, I've just been reading some things about some of the local police things that have been happening. We're just,
Yeah.
it's just so hard to conceive of how we can treat other human beings that way and then go back and act like a so-called normal human being, normal person in society. And the more people we train and enable to experience the power over other people this way, and then I have to make the jump to the political situation that our country is in at this moment, and what happens next November, and if executive power is in the hands of somebody. I mean, not that it's been something that we would look at as something we admire in some ways, but it could get worse.
Well, yeah. I mean, thanks, Denny. So a couple of responses that I think are important to what you've said. So the first one is that there is a film. It's a documentary film called Guantanamo Diary Revisited.
Uh-oh.
I believe Frank may have accidentally clicked out of the call. Hopefully he will join back
We'll
in.
go back. I can send him an email quickly.
While we're waiting for him to come in, my overall feeling is that it's so humbling to hear that. And it's so disempowering unless we pull together and do what we can do.
Yeah.
I was definitely seeing some of the names, especially the people on that war council, was like reminding me of all these memories from 13, 15 years ago of like,
Yeah.
all of these legal memos coming out and just, yeah. I mean, I got like probably episodes of The Daily Show jumped into my head when I saw Alberto Gonzalez and the, and some of the, because I just remember, yeah, I remember that period was, when all that stuff was coming out, I was, um, paying a lot of attention to that. So,
I sent Frank a email, so we'll see if he comes back on.
Thank you.
Yeah, I remember. I think John Yu is still a law professor.
Yeah, I think
out
he
in
was a law
California.
professor out in Berkeley. I really, really didn't like him then, and I like him less now. But it's hard to imagine even psychologists who should have just like me as a psychiatric nurse, we have, there's certain, it's like doctors take an oath not to do any harm. So do these psychologists, so do the nurses and medical people who must have been present force feeding prisoners. And it just blows my mind.
There he is.
Hey, I'm so sorry. My computer died. I don't know why. Is
Oh.
Denny still on?
I'm here.
Yeah,
So let me just finish what I was saying. So on what happens to the people who did this, the torturers and the interrogators. So there's a documentary film that's called Guantanamo Diary Revisited. And if you know the film The Mauritanian about Mohamed Slahi, who was from Mauritania, a Hollywood film was made about his, experience in Guantanamo. So this documentary is a sequel to that film, but it's a documentary, and it's two journalists who actually track down his torturers and his interrogation team, and they interview them. And what's eye-opening about this film is that you see that the person who tortured him was traumatized. It's apparent in the film, and the other you see how the interrogation team is after the experience, and I highly recommend seeing this documentary, Guantanamo Diary Revisited, because it's a window into the world of the people who tortured and interrogated. Yeah.
Mm.
And there was a second point I wanted to make, Denny, and I forgot it. It'll come back to me. Yeah.
So Frank, how do you manage knowing all that you know and being involved in this, and how do you do self-care?
Oh, well, look, community, spiritual community, and just, keeping a perspective here, so for those of you who don't know me, I sort of try and live out, a nonviolent spirituality, right? And so just keeping that always, centered is what helps me get through all of this. That and community and friends. Yeah. And so the other thing I was going to say, Denny, was that, talking about, Donald Trump, I mean, if he wins the election, he believes in like a super, expansive theory of presidential power. I mean, he wants to be king, so yeah.
It's pretty terrifying in itself.
Yeah, it is. Yeah.
Yeah. I wonder if you have any thoughts on, I just think of when Obama was elected, there was this big thought of like, we're not going to look backwards, we want to look forwards. And also thinking of, all of the hesitation of releasing folks from detention. I wonder, like, thinking of how do we have that national conversation of like reckoning with wrong having been done, and also, like, yeah, how do we reconcile it as a nation without, without that damning nature of it, like the moving forward and processing it as a society? Do you have any thoughts about that, or like, yeah,
Well, yeah, I have lots of thoughts about it, but you know, I we're not a polity, we're not a economic political entity, the United States, that really wants to reconcile. In fact, we're non-reconciling, and so I don't think that conversation is going to happen. But the only way it could happen, right, is if we lay a basis, a foundation in our government to allow, a conversation in our media and in our society about what we've done that was wrong. I mean, look, the Iraq War was wrong. There's no reconciling about what we did to that poor country at all. The fact that it was based on lies, etc. Right? Afghanistan, there's no reconciling, at all about what we did to that poor country. And so I don't see it. And look, the way I look at this is that the U.S. is an empire, and empires look forward. They don't look back, and they look forward to continue their own aggression, and they don't admit mistakes, and so, I mean, that's the situation we're in. And if we, to change it, we're going to have to change the nature of our polity, and that involves everything we try to do to make this place a better world. And that's the only way we're going to do it, through electoral politics and through living in community and through, instilling, a kind of a culture that's not violent. Yeah.
But remember what William Faulkner said: the past is not dead. In fact, it's not even past. All still with us. And we certainly have a history of trying not to reconcile, not to look at everything from slavery to Native American genocide, whatever you want to look at. Occasionally you have Frank Church elected to the Senate, and you get the Frank Church Committee that can hold up some of the things the CIA did, but that's rare.
Yeah. I mean, I want to make sure too that it's not a hopeless situation, because, the fact is that people trying together to make the place a better world is a good thing, and it gives hope to everybody. So we try and we do what we can, and as we do it, we leave time for celebration, and we leave time for friends, and we don't get caught up in efficiency or in measuring how much we've succeeded or not, and we just live to make the world a better place. And I mean, we live in a hard time, as other people have lived before us in a hard time, and occasionally there'll be a miracle, either a Frank Church or something else, like you said, Judd.
Well, if you come back to Maine, we'll celebrate. As long as there's not a snowstorm.
No, whatever. Yeah, okay.
I'm reminded of the words of one of the songs that Women with Wings sing. In these hard times, there will always be music, always be singing in these hard times. And that's what community brings us together and helps us be a harmony, even in the hard times.
Yeah. Thank you.
Well, thanks a million, Frank. We really appreciate it. And we'll try to get the word out and each of us learn more ourselves.
That's all right. I mean, thanks for staying with me for an hour and a half. That's
Thank you.
good. Okay.